This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication. It's in the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing. And I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on the state's request to publish Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rizzo versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rizzo and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rizzo because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rizzo, Estes, and Skilling. Unlike the broadcast interrogation in Rizzo, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert, if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court.